period of the X dollars. Again, I wonder if that is right. We are here concerned with damages for breach of contract.
Yes.
Would he have to show that during a relevant period, and let's not enter into what the period is, he wasn't paid money for a driver, or a driver was not provided at Frontline's expense, whereupon he had to drive himself or pay a driver himself, and his loss is the cost of that?
Yes.
Which he hadn't done.
No, that's correct. The approach taken there is he would have been entitled. I mean, it depends on the kind of what your finding is in relation to termination against resignation.
That's why I just said a relevant period. I'm being extremely general.
Absolutely. And so if it was a termination, so to speak, but without cause, then it's a loss of a benefit, and we've attempted to quantify.
Even if it's a resignation, it's the same, isn't it? He says, I resign, you should have provided me with a driver, you didn't. What is my loss?
It would be
the loss is constituted by whatever I had to pay myself for a driver.
Or the loss of the benefit in terms of the future loss. So if he resigned, then his notice period is 3 months, which he worked out, taking him up to February. So it would be the loss of the value of the benefit for the following 3 months.
But the value of the benefit is measured only by what he
would have paid out, or did pay out.
Yes.
I can see that argument, but I put it only as far as this. It's the loss. It's an attempt to quantify the loss of the benefit going forwards in the future.
Next one, head is payment in lieu of out-of-pocket expenses. What's the source of the entitlement to receive out-of-pocket expenses, please?
Asif's Adil evidence was cases that it was agreed that he would be entitled to out-of-pocket expenses.
Well, where's that in the employment contract?
It was verbally agreed, and he's provided his losses attached to his retirement.
I'm not aware, I do not have in my mind at the moment any evidence of the verbal agreement, nor am I aware that you have sued on the verbal agreement. So let's take that in stages. Where is the evidence of the verbal agreement?
Yes. It arises out of the 3rd of October 2013 minutes. So expenses on various projects. The minutes are at tab 92, page 542A, and if I can just read out expenses on various projects. It was agreed that from 1st of October 2013, all expenses related to projects undertaken by FDP and its group venture companies, viz. Mozambique Venture, Kenya and Tanzania, and any other venture undertaken in the future will be reimbursed to FDP by the respective ventures. And then...
Well, that's not, number one, that's not a verbal agreement. That seems to be a written agreement.
Yes.
But that's the agreement you have in mind, isn't it?
That is the agreement that I have in mind, and then Mr. Chaturvedi was asked in cross-examination. What's the page reference? Page 251, presumably the second day. Let's bring that up.
251, you said?
Yes, page 251, day 2. At the bottom of that page, it was also agreed that expenses relating to FDP projects would be reimbursed. That's in relation to the 3rd of October meeting.
Just hold on a second.
at page 250, I ask Mr. Chantovodi whether the minutes on the 3rd of October record accurately the discussion, and then we go forward discussing what was discussed in the 3rd of October meeting at the bottom of 251. It was also agreed that expenses relating to FDP projects would be reimbursed. Over the page 252, yes, that was my intention.
I have that on page 250 of my transcript. I don't know if there's a difference.
250 for me ends with, you do recall that it was agreed during the meeting that there would be an amendment to the employment contract. That's the last insertion. Page.
Well, the pagination is a bit odd, but I have the passages that you just mentioned. Well, so this is not a claim under the employment contract. This is a claim under a contract said to have been made on the 3rd of October.
Well, we say that on the 3rd of October discussions took place to amend the employment contract, and what the 3rd of October minutes do is provide in writing those amendments agreed to the employment contract.
Right. Okay, so again then this must depend upon the original employment contract not having been terminated.
Yes.
And resignation.
Yes.
So the line of argument must be, I am suing on the employment contract as amended
By.
Right, okay. Right, I understand what you, how that is put. Okay, well now, still taking these step by step, I'll go back to Mr. Dow and see what he wants to say about that. I had not appreciated that this was the way you were putting it.
Yes, so we say the 3rd of October minutes constitute an amendment. The discussion was a variation. The minutes themselves constitute an amendment, an agreed amendment to the employment contract. And I say that because the first page, right at the top, says after setting out who was present, basic salary payments, the employment contract will be amended as below.
Yeah.
And then this is signed.
Or does it follow from that so far as a claim is made on the basis of resignation for unpaid salary, the salary is not $50,000 a month, but the lesser amounts that we talked about on the 3rd of October?
That would follow, yes, from the 3rd of October
And
date.
ditto equity grant, but I forget exactly what the minutes say, but insofar as there is a different basis or amount for equity grant, that's the sort, that's the entitlement.
It would have to follow, yes.
Right. Well, I wonder if we're getting into a bit of deep water here, that this was not the case that was run, but anyway, I hear what you say. Mr. Dow, what do you want to say about this?
Well, it's not the case that was pleaded. You probably noticed already from the pleadings. It's not the case that was run at trial. It's never been suggested. It's always been suggested that the minutes of the 3rd of October provide the court with insight as to what the obligations and the rights of the party were before that date. In other words, under the existing contract. But it's never been suggested that following the 3rd of October, the claimant's new employment terms were actually came to fruition, and therefore that the claimant, or if they did, that the claimant is now suing on those new terms.
Well, that Altamemian Code in 2014 wrote saying we terminate the deal in October.
Correct.
Too. Now, there has certainly not been any litigation one way or the other as to whether that's right or wrong.
Yes. But nobody, the claimant hasn't brought a claim on the basis of that or a new contract, and the defendant hasn't defended a claim that doesn't exist on that basis.
Yes.
So,
okay, I understand that, thank you, yes. All right. Anything further on that subject, Ms.
My Lord, I'm not going to raise criticisms about the pleadings because the case that was then run at trial that is now being presented is completely different to the pleadings in any event, even on the
That's not a
defendant's part.
confession that anyone should make.
But it just in terms of my closing submissions, I refer to the 3rd of October meeting, and it's paragraphs 177 to 180.3 that deals with this point that the 3rd of October meeting minutes.
But your point there was that what happened in October shows that there was never a termination. That was your point then.
There was never
But not an effective termination.
Not an effective termination, but also that, and in my closing submissions I raised the point that it constitutes, the minutes constitute an amendment to the employment contract.
All right, okay. Well, now, the last thing that I have on my list then takes us to this question of penalty.
Yes.
There are a couple of things quite apart from the submissions about discretion or not discretion that I have received. Again, Miss Ahmed, I think it's probably best if I raise this through you. Could you turn up Article 18, please? Somewhere, I can't remember where, there's a definition or a description of wages.
At the end, in the, not the appendix, but right at the end of the employment law, Schedule 1, I think it is, sets out the defined terms.
Page 20.
That's it? Yes, thank you. Okay. Well now, if one asks, and again I'm just trying to explore this as a matter of principle, that it can apply differently according to when there might have been termination or resignation. But let's again just take the 30th of June as a date and assume a termination, an end to the employment. That's enough.
Mm-hmm.
One has to ask what wages were then payable and had to be paid within 14 days. Salary strictly so-called, $50,000 a month, would be that, at least as at 30th of June, that was not unpaid.
Mm-hmm.
So one then has to consider the other claims that are being made, that is, the notice period payment, the equity grant, gratuity, and so on. The question is, are they wages within this definition?
We say yes because you quite rightly pointed to Schedule 1 of the Employment Law. Article 18.1 says shall pay all wages. There's no distinction there as to basic wage or daily wage, which is provided for in the defined terms of the employment law.
Well, let's test this by gratuity. Let's assume that by the operation of the article dealing with payment of gratuities, that a gratuity is payable on employment. Can we find that, please?
I beg, gratuity in the employment law?
Yes.
Yes. It's Article 62, page 22.
That's it. Thank you. Righto. So there's an entitlement to a gratuity payment at the termination of the employment. Now, is a gratuity payment a payment in return for work done or services provided?
Well,
It comes right at the end. It comes because the employment is terminated and there are no more services.
and precisely for that reason we would say no. Going back to the definitions provided for in the employment law, wages is defined as means all payments made to an employee in return for work done or services provided under the contract of employment.
Well, so would you agree that insofar as a gratuity was not paid within, if it was payable, was not paid within 14 days after the employment came to an end, that would not attract a penalty?
Shooting myself in the foot, probably, we would say yes, it doesn't attract a penalty because that's not provided for within the definition of wages.
I may say that occurs to me to be correct.
Yes.
So it's entirely appropriate if that's what the way you see it, also
Yes.
you should say so.
Yes. So it's not provided for in the definition of wages. The definition in Article 81, there's no distinction. The distinction as provided for in defined terms, be it basic or daily wage, and therefore wages should include the gross basic salary as defined previously.
Okay. Well, now let's take a notice period payment.
Yes.
If there is 6 months written notice,
Yes.
then salary and other benefits will continue to accrue. So if at the end of the 6 months they're not paid, well, okay, one can, I think, accept that they would be wages. But if that's not it, and if the alternative we were talking about earlier today is the correct one, terminate without notice on payment of a sum in lieu of notice, is that sum in lieu of notice wages?
Again, I would say no. I think it's whatever is due to the employee under the contract as part of his everyday work.
Right. Okay.
So there is nothing in here apart from the reference in Article 18.1 after the employer or employee terminates the employment. That's just the termination of employment is just a date by which you take for salary to be paid, wages to be paid.
Yes.
So it's just a trigger date as opposed to any entitlement accruing arising out of termination of employment.
All right. Okay. Well, now, payment in the driver's charges,
Yes.
the obligation to provide a driver was rather amalgamated with what we were talking about earlier. It doesn't seem to me that the obligation to provide a driver up to a particular value would be a payment in return for work done.
I just want to go and refresh my memory about what it says in terms of the driver's clause.
Yes, I think it was clause 12. Remember?
It's earlier on in the contract, 6, 7. It's part of. This is the page missing. I think it's 12. I've got those pages missing as well. Eligible for women provided by the constructor maximum for I would say it does include that because it's all payments made to an employee. If, for instance, Article 18.1 said basic wage, then we go back to the definition which excludes any allowance for benefits such as drivers.
But it's not where is there a payment made to the employee? In the when things were happy and the employment was good, no money was paid or payable to Mr. Adil. Instead, the driver turned up to his door every day.
No, I mean, my lord, you're quite right, and there is a gap in the evidence in terms of whether or not the company paid or whether or not the company paid us and we paid.
I don't remember a single bit
No.
of evidence about the driver, to be honest.
There is, and I stand with you. I can't remember anything about the driver, and I've had a quick look, and I can't see anything that springs out. So maybe I might just leave that there, and unless you hear from me further, there probably is no evidence.
Well, if I do hear from you further, it's going to be before we all part today.
Of course, I understand that.
All right. Now the more difficult one might be the equity grant. Depending on other things, I may have to consider whether what the contract says about the equity grants, and I'm putting that very loosely, means that there is a payment made to the employee in return for work done, etc., etc.
I simply go.
I can see both ways on this one.
Yes.
So what I think I would like to have is what you say, how you would like me to put it, and then of course I'll hear from Mr. Dar on the way he would like to see it.
Yes.
Regarded.
I go back to my earlier submissions as to whether or not it ought to be taken into account when looking at basic wage under the notice termination provisions of the contract. I would say that the claimant, it does form part of the wage because it was a contractual entitlement. The way in which the contract was formed was that there were discussions as to what this equity grant payment would reflect, and that was a top-up of the claimant's previous compensation.
Just to interrupt, to say it's a contractual entitlement doesn't really answer the question. We're looking at the words payments made. I think we can accept that it was in return for work done. What's it? Is it within the words of payment made? That's the tricky bit.
Payments were made. Some payments were made. Others were due to be made. Over the course of the relationship, we say in the claimant's case is that the defendant agreed that they would be paid, and so we say that it does form part of all payments in the definition of wages.
Does the fact that in the way we've earlier discussed it was conditional payment, that is a payment on terms that it be invested in the group company, make a difference? One way of looking at it might be that although the benefit was the requirement was to be discharged, although the way of fulfilling the equity grant obligation involved a payment of money, it was in substance
Conditional.
in substance the provision of shares, because the deal was to go into that will be put into the group company. So it wasn't a payment really, not really, if I put really in quotes.
But again, I go back to it, there is no provision within the law as to what happens to the payment, and therefore it goes back to your sort of two-step analysis. Payment was made, but that was then used to contribute to joint ventures. If we take it simply as payment that was made, then it gets us within this definition. So we would say that we don't need to look at what we needed to do with the payment. It just simply stops at where payment was made.
Well, another way of testing this might be that, let's assume we've got this last month, last quarter, from April to June.
Yes.
Frontline could have said, I'm not giving you any money, I'm giving you shares to the value of $125,000 in the cosmetics venture.
Yes.
Here they are. Could have.
That, yes. But it didn't.
No, well, on the hypothesis where it didn't do anything.
No.
So you can't. So saying it didn't, it doesn't take you much further.
Well, let me take that in two steps. If it's right, FDPL could have done that, and if it did, then there would necessarily be a hurdle to my argument that that's payment for the purposes of Article 18. However, the approach that I would invite the court to take is, during the currency of this relationship, what actually did happen? Payments were made, and therefore, looking at practice or custom, it was payments that were made to reflect the benefit under Clause 7. And that's, in these circumstances, I would invite the court to approach it.
Well, no. I'm sure you can see why I'm trying to explore
Of
these.
course.
I've been thinking about these as possibilities, and
Yes.
I wanted to hear from you about it. Anything more you want to say on that matter?
No, I don't. No.
I'll hear Mr. Dyer on that. Yeah, what do you want to say about this?
Do you mean on Article 18 as a whole, or just on the
No,
2
just on this question of what is
Yes.
of whether these various heads of claim are wages.
I think in terms of whether they're wages or not, I mean, Your Lordship has obviously noted that the provision allows for any other amounts as well. If you just read on, which takes care of the dilemma that you're in. In Article 18, employers shall pay all wages and any other amounts.
Yes, true.
So that could take care potentially of the more
It still
difficult
says
ones.
amounts, though. Yeah. I appreciate that, and I'm glad you drew that to my attention. I did not have that in
So
my
I have to.
mind.
But in terms of the equity grant, that does throw a slightly different issue in the court's way. If Your Lordship takes the view that what the claimant was contractually entitled to under the contract was a grant of equity in its only sense, I would say, you may say its narrow sense, that is to say, shares, giving you shares in the company, then arguably other amount owing doesn't, and neither does wages. So that doesn't fall within the definition of wages as we see it, because it doesn't comprise of payment, and it doesn't fall within any other amount owing for the same reason, because the word amount means, I would suggest, a monetary amount. That's the only way one can sensibly construe that. In which case, a grant of shares wouldn't fall within either of those two definitions. However, and incidentally, if you were to take that view, then it's difficult to see how Your Lordship could find that the defendant was in breach of its contractual obligations, given that Frontiera never became a group company because it never owned any shares in Frontiera. But that's a different point, obviously. But just on that equity grant point, it's difficult to see how it could fall within either wages or any other amount owing. And in terms of the other amounts, for example, expenses, or if you were to take the view that the claimant had submitted his loss and evidence of his loss, either of expenses and of the costs of a driver, then they could fall within the definition of any other amounts owing under the contract of employment. But there may be difficulty in putting them into the wages category for the reasons that you've identified.
But I did not have in my mind the or any other amount. That would foreseen that a gratuity might then be caught by that,
Indeed.
which would mean that in just about every case of termination,
Yes.
indeed in every case of termination of employment, a gratuity will become payable, and if it's not paid within the 14 days, the employer is in big trouble.
Indeed. And the far-reaching nature of this particular penalty is a reason why I'm going to be inviting this court to...
Yeah, well, you embrace that because that's part of your argument.
Indeed.
It's a result which should be avoided by discretion.
I'm in your hands, Your Lordship, how you'd like to deal with that, because there are submissions I need to make on it. And you
Well,
may think they're important.
I don't quite understand what they might be because you've made some very full submissions, but if you want to add something to them, yes, now's the time. The last item is this question of discretion or not under Article 18. By all means, add to your submissions, but before we do, any response to what has just been said about whether the various heads might trigger Article 18? It's in your favour. It seems to be acknowledged that a gratuity,
Any other
if it
amount,
becomes
yes.
payable, for example, would trigger it. All
Yes.
you need is one. You just need one bit of money.
Yes, yes, one, yeah, yes, one feel that might be owing to a potential claimant, but I don't have any further to add apart from the observations that my
Okay.
Lord has made.
Well, the last matter then is, if either of you does wish to say something more on the question of discretion or not in Article 18, that's the matter that I gave your attention to in an email which was sent at my request to you. I do have quite detailed and submissions which I thank you, so I hope that there's not much more you're going to say. Mr. Dow, I'll hear you first.
Yes.
Right. Lordship, I just want to take you to one authority, and that's the Federal Steamship Authority, which is in our authorities bundle, the Defendant's Authorities bundle. Disappeared from my It's a tab 8.
Yes?
Your Lordship, I want to refer to this case because it's an important decision. It's a House of Lords decision. And a number of authorities that my learned friend has relied upon in order to steer the court away from, if you like, embarking on, let's call it surgery rather than therapeutics, at this particular piece of legislation, are all decisions other than the decision of the highest court in the UK. And this is a decision in my submission which actually highlights circumstances in which editing has occurred. Very small editing, but editing with a substantial effect. And it's the judgment, which is a dissenting judgment of Lord Reed, that I'd like to highlight. Just a bit about the case, Your Lordship, but I'm not sure if you have an opportunity to read it.
With all the eminence of, well, it's an extremely eminent bench. Lord Reed is very eminent, but if he was dissenting, does that not cause a problem?
No, for this reason. Three of the bench decided to refuse the appeal brought by the ship owners and or the master, that the meaning of the word "or" should be read conjunctively rather than disjunctively. In other words, that where it says you could bring a claim or a prosecution against the ship owners or the master, what it really means is "and." And that was appealed against, that decision. That was a decision of the Court of Appeal, that they dismissed it. They said that you could read the word "or" majority of the House here, the House of Lords, upheld that decision. They upheld it because they felt that all, in these circumstances, could be read conjunctively. Lord Reid took a different view. He said it's not possible to read the word all conjunctively. It can only ever mean or and not and. But what he did do is, and thought that in this particular case, having regard to what he thought the intention of Parliament was, that Parliament intended for all to mean all and not and. But what he does quite nicely is he rehearses the circumstances in which substitution, addition or nullification of statutory phrases can be undertaken by the court, and that is not obviously disputed or criticised by any of the other three law lords. And he starts, Your Lordship, at page 508 of the bundle, and in particular at paragraph G, just to the right of the first hole punch. It says, there is, however, another principle of construction. In very limited classes of circumstances which I must later examine, it has been held proper to strike out a word from a statute or other writing, and to substitute one or more other words for the word struck out. That is something much more drastic than giving a secondary meaning to a word as a matter of construction. And then he goes on to set out the circumstances in which that can be done. And if you go over the page, Your Lordship, page 509, paragraph B, he highlights three cases where it's proper to strike out the word or indeed to substitute for it. That's paragraph B. Where without such substitution the provision is unintelligible, well, that's not the case here, it still makes sense, or absurd, or totally unreasonable. We say here that giving the plain and natural meaning to these words and not substituting the word shall for may, which is one potential course the court could take.
The word may for shall.
Indeed, sorry, may shall, would lead to absurdity. We've covered what that is already. And would be, more importantly, totally unreasonable for the reasons that we've already identified in our closing submissions. So it was suggested that it is, what is required is for unintelligibility before the edit is made, or absurdity before the edit is made. We say that's not the test. It's sufficient for it to be totally unreasonable. Now, importantly, this judgment was expressly approved, the dicta was expressly approved and relied on in another judgment that is in tab 9 of the bundle. And that's a decision of Justice or Deputy Justice Stephen Morris, sitting in the Queen's Bench Division of the High Court in 2013. And Your Lordship, this is a case that concerned whether or not the permission to erect a wind turbine by an inspector of the Secretary of State following an appeal against the decision of the refusal of that permission by the local authorities could be edited so as to ensure that it made sense. They regarded the decision of the inspector as a decision of the Secretary of State effectively a regulation. So for the purposes of this exercise, it is helpful. And the relevant part is under paragraph 18 of tab 9, General Principles of Construction. And here you see the court expressly approving Lord Reid's dicta, circumstances in which that kind of editing exercise can be undertaken, those three heads that I've identified. And they refer again to the head which says, where without such substitution the provision is unintelligible or absurd or totally unreasonable. So again, that's expressly approved as of 2013. I make those points because my learned friend says we must adhere to the dicta in Gray and Pearson, which is to say, and the way they read it is to say that the court can really only interfere to modify the sense of the words where there is absurdity, repugnance or inconsistency with the rest of the statute. And they say there has to be that before the court can intervene. We say there doesn't have to be that. The result is sufficient for the result to be totally unreasonable, even though the statute is still intelligible for the court to intervene. That's my primary submission.
Yes.
I say, Your Lordship, if you don't have the will to edit, so to speak, for a variety of reasons, or you feel that the test for editing isn't satisfied, you still have the ability to give this a strange and unnatural construction. And Your Lordship will see that I highlighted the way in which the courts, in a number of cases, have determined that the word shall, used in various statutory contexts, can be construed permissively and or in a manner that suggests they are directory rather than imperative or mandatory. And that's quite important, that's explicitly recognised. And Your Lordship, if you have the opportunity, and I've taken these cases from Stroud's Judicial Dictionary, there are a multitude of cases where shall has been construed permissively. I should add, there are a number of cases also, to do justice, my learned friend, where the court has decided that shall should be construed in a mandatory fashion. But in short, and in case this has been lost in the submissions, even if you were to take a strained approach or take a substitution approach, what you create is a discretion. And that discretion still affords, with correct judicial application, it still protects employees from the mischief of employers who are dilatory or deliberately withhold payments. Because the fact that the provision is no longer mandatory won't prevent the court from exercising its discretion in the appropriate cases so as to impose a penalty in circumstances that warrant it.
Well, one consideration might be that if there were to be a discretion, there's absolutely no guidance given on how the discretion is to be exercised. And it would be rather odd to simply say to a court, you can impose such penalty as you think fit, if you think fit, full stop.
Well, Your Lordship, I can see that there are practical difficulties that arise if you were to import a discretion and give this a strained interpretation. But they're not insurmountable. Courts have imposed penalties based on ordinary principles. Make sure the penalty meets the crime, so to speak.
No, but usually in a criminal context, there's usually a statute or here a decree which says shall be liable to an offence of a fine of X or
yes.
imprisonment for Y,
yes.
and you've got something to go on.
Yes. What we've got here, Your Lordship, is a way of calculating the daily rate. It's been carefully set out under a definition of wages. We know how to calculate it. So, just looking at this practically, Your Lordship, if you decided to impose a penalty in these circumstances, you may say, well, let me start by looking at the number of days that you have been in arrears. And in this case, the total amount is 250 days. And you're going to be paying $2.4 million. However, having regard to your conduct, having regard to the conduct of the employee, whether this was a willful default or whether the employer was innocent, taking all these factors into account, I'm taking to the extent that you may have contributed to the delay in payment, in other words, some form of contributory fault, and I'm going to reduce that total amount by 50% or by 25%. Now that would be a sensible way forward. I appreciate there are no parameters or guidelines provided in the legislation, but we are in, as it were, a new jurisdiction where this particular provision was passed in my submission, with great haste and without any real invitation for debate or any real debate whatsoever. Nobody at any stage wrung out the different consequences that would flow from this piece of legislation. So in my submission, it's been done before, and it can be done again. That is to say that there is a degree of, I won't call it aggressive, but considerable judicial intervention in fine-tuning the practicalities. That is to say, to use judicial experience, and we have a wealth of experience in the DISC from a multitude of different jurisdictions from which we can draw in order to determine how the remedy should be calculated. And my proposal in my submission is not a difficult one to use. Take it to the end and then make a deduction, percentage deduction, based on fault. And you're also, I know that my own friends have referred to a number of different jurisdictions, as you quite rightly invited them to do, but all of those cases that they've put forward can be characterised in this way, i.e. legislation from other jurisdictions. Either there is a discretion whether or not to grant or to make a penalty, or if there's no discretion, the amount of penalty is discretionary. There is a discretion in there somewhere. In this case, we appear to have no discretion whatsoever, and I'd invite you to presume that it wasn't the intention of the legislature, the DISC committee, and or the ruler to create the results that have been created as a result of this. And if you were to draw on penal sanctions from across the world, you'll see that they all have a single hallmark, which is they enable the judge to enable the penalty to fit the crime system, but tailor-made sanction.
Thank you. Thank you. I appreciate those additions.
My Lord, you do have our full submission, so I won't take you through them in any great detail. Suffice it to say, I'll respond to a couple of points made by my learned friend. He relies on Lord Reed's dicta in saying that that has been approved in the case of Newark and Sherwood District. I have that open in front of me, so I'll just recite from there what the relevant wording is. Cases where it has been properly been held that a word can be struck out of a deed or statute and another substituted can, as far as I'm aware, be grouped under three heads, where without such substitution the provision is unintelligible or absurd or totally unreasonable, and he relies on the totally unreasonable aspect of Article 18. But reading on, the dicta does provide where it is unworkable and where it is totally irreconcilable, should I say, with the plain intention shown by the rest of the deed or statute. Now, if we go back to the employment law and the statute, we say that Article 18 is not irreconcilable. If you look at the purpose of the employment law, this is something raised in my submissions.
Well, that really doesn't meet Mr. Darr's point. Mr. Darr is saying that the option of totally unreasonable is an entirely separate one. Indeed, he stresses that in order to say that it is not necessary that it be irreconcilable with the intent of the statute. He tries to undermine your authorities in that way.
Indeed, and I take the point, and I simply add that Article 18 is consistent with the purpose of the employment legislation. And then that goes to the question as to discretion, and my learned friend invites you to change the wording so that it provides for a discretion. And what we say is that the rule maker's intention can only be gleaned from, again, Article 3 of the employment law, that is to provide protection. Article 18.1 protects the employee by insisting and making it mandatory for an employer to pay wages within 14 days of termination. What Article 18.2 does, however, is provide a penalty for any employer's unlawful actions of not paying wages which are due within the 14-day period. And so, with that in mind, then to change the wording to importer discretion is completely changing the law, which isn't provided for by any other statute or anything else.
I understand all that, but let's just go back for a moment. I don't think it's right to say that Article 3 says the purpose is to protect employees. Article 3 is...
Provide minimum employment standards, promote the fair treatment of employees and employers, and foster employment practices that will continue to the prosperity of the DIFC.
Now that's... these are rather apple pie sentiments.
Yes.
That probably don't take us very far one way or the other. They can be looked at both ways. Mr. Dar says fair treatment of employees and employers, and it's not fair on the employer.
Well, then Mr. Dar also says that the rulemaker couldn't, if it would have thought through the effect of Article 18.2, it would have realised the absurdity that Mr. Dar says would be achieved. And we say that Article 18.2, on the face of it, does perhaps show that the rulemaker did look at this, because not only does it say wages, but any other amount as well. So clearly we say that the reference, not just simply to wages, but any other amount, is a reference to the rulemaker clearly thinking out a deterrent.
He has cast a wide net, and he has specifically said this is a penalty. I'm out to penalise employers. So
Yes.
I can quite understand an argument on your side that says, so far as Mr. Dar submits that this would be harsh on employers, well, so be it.
Yes.
That's what was meant.
Absolutely.
That's your argument.
Absolutely, my lord. And what I would say to that is that the reason why it may be perceived to be harsh is because by not paying what's due to the employee within 14 days, the employer is committing an offence under the Act. It's unlawful not to do that, which is why this penalty is the way in which it's worded.
What about the situation where entitlement to be paid wages is in dispute? You could have an ordinary case, not as complex as this, where there's dispute over whether there was a termination for cause. Someone is terminated for cause, purportedly for cause, but the court then says wrong. Money was payable. And it's taken a year for the court to say that.
Under those circumstances, my lord, what we say that this Article 18 is directed towards is all those sums that ought to have been paid.
Yeah, and so when the court says the termination was wrong and the sums ought to have been paid.
One of the submissions.
Please.
Oh, sorry.
Yes, so, my lord, just in response to the scenario put forward, the employer it's always open to the employer to protect himself where there is a dispute by making, well, in this jurisdiction you can make payment by cheque and you can sort of post-date it or put it in an escrow account. And so it's open to the employer to protect itself under circumstances where there is a dispute.
I'm not too sure that would be payment for the purposes of Article 18. Your answer, seems to me that your answer has to be, well, yes, that all that means is that employers have to be particularly astute not to to terminate wrongly. And if they do terminate wrongly and end up with a
Very
big bill
consequences, yes.
under Article 18, well, that's their problem. I'm putting it fairly loosely, but I think that has to be the sort of argument or response you give to me, doesn't it?
Yes. Yes, the provision is what it is. The employer should take measures to protect itself and should do things properly, in which case, and take extra care in terms of the decisions that it makes. So yes.
All right.
I don't have anything else to add to that. Thank you.
Okay. Mr. Dara, I know you wanted to intervene, and this is not a never-ending session.
Yep.
If there's anything properly in reply, then please say it.
Just the one point, which is, if your lordship looks at the old law, if I can call it that, before the amendment in 2012, there's explicit reference to other jurisdictions within the context of minimum standards. Perhaps I can just show you that. It's paragraph. In fact, if you turn to tab 4, you'll see the old law and track changes that reflect the new law. So tab 4, and if you go to section 3, which is the purpose section, you'll see there that in paragraph A, the original draft said, or the original law said, ensure that employees in the DISC receive the minimum international standards and conditions of employment. Now, it's difficult to know which jurisdictions we're referring to, but I would make this general point. By and large, other jurisdictions, older jurisdictions, with historically more entrenched employee protections, are what is being referred to here. And after inviting consultation on this point, the section was deleted and replaced with minimum standards without any international reference. And you may think that that's telling. And I would venture to suggest that what the DISC legislative authority was trying to do here is to not strangulate employers by imposing upon them the sorts of protections you might get in France or the UK or in any other jurisdiction, where really an employee is an employee for life and benefit from what I would call gold-plated or Elysian standards of employment protection. And that was never intended in the DISC. And so I'd invite you to take that into account when you're considering whether the presumed intention of the legislature was to grant an absolute entitlement to a draconian and disproportionate penalty, come what may. And just to end, if one does the math in this case, based on there being 250 working days in any 1 year, and the employee's salary, the claimant's salary being 2,300, dividing 600,000 by 250, $2,300 a day, and then multiplying it by the number of days that have elapsed, so not working days now, days that have elapsed, you come with a figure of around $2.4 million. Now, your lordship, depending on how you decide this case, if, for example, you decided that there was an entitlement to 6 months' salary, which is around $300,000 and possibly a bit of equity, I'm not inviting you to do that, this would represent a 300 to 400% uplift on any award that you make. And I would suggest, therefore, it's reasonable to conclude that that is productive of a disproportionate counter mischief, which wasn't foreseen and wasn't intended by the legislature.
All right, thank you. Well, we're at the end of the matters that I wanted to raise with you, and thank you. Your additional submissions, in particular on Article 18. What remains, I think, is that SAMED should have the opportunity to put any vital submissions in reply, notwithstanding that they should have been put earlier. Will I adjourn until 2 or 2:30 or something like that for you to get your thoughts in order
Well, my Lord, I've had an opportunity to think through whether or not it's necessary for me to make submissions in reply. At this stage, I don't consider it is. We have submissions that are comprehensive, that more or less cover all points, and therefore it's been helpful to have your sort of guide in hand through the queries that you may have, and so I don't propose to take any more of the court's time on submissions in reply. However, unless you actually want to address any particular point raised by the defendants that perhaps the claimant needs to cover. With that caveat, however, what I would say is that I would like to make some submissions in relation to costs. Now, I appreciate...
Well, what I had in mind, it's all too complicated, I think, to try and deal with costs, and unless either of you wanted something else, I thought I should give my decision in the light of that. I may indicate a tentative view at the end of the hearing. I may even put it in terms, as I sometimes have done. My present view is that the costs should be X. If any, I will order X, but suspend the order for 3 weeks. And if anyone wants to ask for a different order, then they have to apply within the 3 weeks. That's often a convenient way of doing things. Or I may just leave it open-ended with submissions about cost.
Yes, no, I appreciate that approach. I just want to apprise the court of developments in relation to information that we've been requesting and the effect of the lack of information provided to us.
Why are you...
Well, the reason being is that we foreshadow potentially an application on our part to add Mr. Suresh Chaturvedi to the proceedings as a party for the purposes of costs. Now, I appreciate it's...
If you're going to do that, it seems to be a brave endeavour.
It's premature at this point. I'm not going to make the application, my Lord. I just foreshadow it at this point because requests for information about the assets of the defendant has been made. Information hasn't been forthcoming, and as such.
Well, anyway, if you don't want to apply to have him join now, then we'll leave that pleasure until later. On one option, one alternative is that it may never arise because Frontline wins.
Absolutely, in which is the reason why that application hasn't been made, and it's rather dependent upon the judgment that we receive. However, it's there as a background, and the reason being is because information about the assets of the defendant hasn't been forthcoming.
Right. Well, I can see a few happy years of further litigation. Let's see if we can finish it all before I hit the retiring age.
Your Lordship, I just wanted to bring your attention to paragraph 135 of the claimant's witness statement, because I think I may have misunderstood your Lordship, but this relates to whether or not the claimant accepted that he had refunded 23,600 because PDEL had overpaid the amount in respect to payments to suppliers. And he says, in terms of paragraph 135, exactly that.
Yeah, but what he meant was it had paid more than its $300,000 contribution. That's what he meant.
Well, no, because he says that was not a contribution, but part of the consultancy, part of the payment for his consultancy agreement. It could mean that.
Well,
but I just bring to your attention that.
Well,
it's paragraph 135 of the statement.
Right. Okay, well, thank you very much. Obviously, I'll be seeing you again. I will try and get my judgment out fairly promptly, but a few extra thoughts have come up today, which I'll need to grapple with.
We appreciate that, my Lord. Just going back to one of the questions that you raised with me earlier in your bucket list, and that was the reference to White said in our closing submissions that the claimant returned to work on the 18th of September.
Oh, yes.
If I can perhaps go to the transcript, date 2 I may just find it first myself and then I can give you the accurate reference. 28283. It was questions put to Mr. Chatterverdi. And I think, I may just... Yes, if I can give you this reference first, my apologies for taking you to the transcript. If we perhaps can go to F1 first, and it's page 516, tab 89.
We have to.
Pardon? Yes, F2. And this was the letter from Frontline telling
Oh, this is
Consulate of Mozambique that Mr. Asif Adil was an employee of Frontline. And so questions were put to Mr. Chatterverdi, and questions relating to that are at transcript day 2, page 282. And I asked him 282. It was under that obligation that he presented himself to work around the 18th of September. That is correct.
sorry, we may have a page problem.
Yes. Okay. It starts with I asked the question. Let me go back and see if I can find a reference for you first. What can you see at page 282, and then we can work back.
Page 282 is where you're questioning about the email of the 21st of September, and Mr. Chatterverdi said he wrote it with caution.
Okay, so to my 283 is, I say he was terminated. Can I ask you to look at the letter of 21st of September 2013? Is that your reference? It's above page 5, where I mentioned page 513.
I have 51, where you're saying page 513, third paragraph. Is that what I should have?
Yes, so I say yes, third paragraph, recapitulate. So
Yep.
if we go back 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 insertions. 19 rather. And it starts, it was under that obligation that he presented himself for work around the 18th of September, that is correct. Is it not?
16 pages or 16?
Yeah. Yes,
Right.
19 insertions. Or paragraphs.
Or paragraphs, okay. Right.
So I start, below Mr. Chatterverdi saying yes because, and then I say it was under that obligation that he presented himself for work
I
around
see,
the
yes.
18th, that is
It
correct.
was under that obligation that he presented himself.
Yes.
Yes, I have that. That's page 278. I really don't understand how we can get different pages, but
No. And then following that, Mr. Chatterverdi says, which paragraph are you mentioning? You asked me specific day 18. I'm putting to you, I don't remember, do you remember who was at work in September? I don't remember Kington to pay tab 89 in volume 2.
Well, thus far we have Mr. Chatterverty not remembering.
Yes. And then is that one, yeah. Yes, then we look at the 22nd of September letter. These the only two references, isn't it? That's yeah. Right, okay. And then day 3, yes. So then day 3, we look at page 27. And I don't know what's the first entry on your page 27.
I have found something that says, Mr. Chatterverty says he started coming to the office
Yes.
September for some time.
Yes, that's the reference that I was going to
Started coming to the office in September. That's my page 30.
Okay. So Mr. Asif Adil's evidence was that he came to work on the 18th of September. The letter at tab 89F2 is dated the 22nd of September, which talks about Mr. Asif Adil being an employee.
Well, where was his evidence that he came back to work on the 18th?
I think it was in his witness statement. Huh? Yes, his witness statement.
The only reference I found is just as this paragraph 314 of his witness statement in tab 26, where he says, accordingly I continued being employed with FPL during the period 30th of June 2013 and 28th of November 2013 when I resigned, but I haven't found another reference to the 18th of September.
Hello, if I can just have a quick opportunity to check, please. Huh? Yes, so paragraph 235, there's the whole section titled September 2013.
So 235 of Mr. Adil's first witness
Yes,
statement?
first witness statement.
Right.
I returned to the FDPL office in the DIFC in Dubai on 18th of September.
Okay. All right. Well, that gives me an answer. It's looking at a rather uncertain situation. It looks as if it's correct that he came back sometime towards the end of September, maybe not full time, but after October he was pretty well full time on Frontline / Frontera.
Yes.
A very broad feeling that I have is what the evidence might amount to.
Yeah, I mean, Your Lordship, there's probably little, if any, dispute about whether he came back to the office. There may be dispute about, there is dispute as to whether he remained employed.
Of course, and I'm just talking about actually doing work.
Yes.
Yeah.
Yeah.
All right, well, I think that's good enough. I was piqued by the precision, and I did not find that reference in his witness statement. Thank you. All right, well, I'll be as quick as I can. It may still be a little while, I'm sorry. So, as soon as I can. Thank you for your assistance today.
Great.
Jeff.
Safe travels, Mother.